Okay, next case we'll take up will be the Orlando/Orange County Expressway Authority versus Tuscan Ridge.
Good morning, Your Honors. I would like to reserve 5 minutes.
Okay.
My name is Richard Milley, and I'm counsel for the Orlando-Orange County Expressway Authority. We are here this morning on appeal that relates to an eminent domain attorney's fee award. The trial court awarded $816,000 in an attorney's fee after a jury verdict in this case. The trial court's award was based on hourly rates pursuant to Section 73.0922. The Expressway Authority respectively submits to this panel that that award was in error and that the trial court should have awarded attorney's fees based on 73.0921, which is the benefits statute. In this case, Your Honor, attorney's fees are dictated...
Let me ask you this. Let's assume that the tenant wasn't on a month-to-month tenancy, but instead had a 99-year lease in a long-standing, ongoing business. How does the landowner apportion the proceeds in that situation?
Well, first of all, the first question is whether the statute requires at the first offer stage any type of apportionment by the condemning authority when they make the first offer. And our belief and view of the statute is 73.015, which is the statute that requires the condemning authority.
Well, this offer was said subject to apportionment.
Yes, sir.
And that's the key phrase that the trial court seized upon in finding that the offer was not a valid offer.
Well, if you...
So whether or not they had to use those words, they did use those words.
Yes, those words were used because what the condemning authority was saying was we will pay you this amount of money, but in order to pay you this amount of money, you have to provide us clear title, which condemning authorities do all through the state.
Let's go back to my question, and how does the landowner apportion that when you're in a situation where you have a long-term lease?
Well, the landowner has an offer in front of them, and what they have to do at that point is they have to decide whether to accept the offer or not accept the offer. The offer is a set amount of money subject to providing clear title, and the landowner at that point can either accept the offer with whatever risk that entails, or they can go to the tenant and try and negotiate a deal so that there's a deal ahead of the time. But at the offer stage, what the owner has to do is simply accept or reject the offer, subject to the terms, which are that you provide us clear title. There is...
well, let me ask you this. The attorney's fee provision, subsection 1, says you take in determining the benefits, you take the difference between the final result, which we know here what the final judgment is, and what the offer was before the attorney was hired.
Yes, sir.
What was that figure in this case?
What was the
second figure, what was it in this case?
The first offer.
The first offer. All right. Now, if you had a 99-year lease, would the first figure still be the same?
Yes, sir. There is a case that I actually just learned about.
One more question. If you have a dispute between the person with the 99-year lease and the owner on who gets what portion of the $4.7 million that was offered, or whatever the exact figure was, are they entitled to attorney's fees from the expressway if they have to litigate that?
Well, you're always entitled to attorney's fees for an apportionment hearing in any apportionment dispute, and that's subsection 2. So any time that you have a party that has an interest that's not the fee holder and they are litigating what their apportionment rights are, they clearly have a right to attorney's fees.
All right. So if following up Judge Cohen's example of the 99-year lease, if you do an offer for $4.7 million, fee holder accepts it. Now they litigate, and you all don't care. However, the $4.7.
That's right.
Are you going to be obligated to pay both fees under subsection 2? Or just one, or how's that going to work?
Well, what typically happens is the party that's not the fee owner, they have an apportionment claim, and so their fees are dictated by the apportionment statute, which is an hourly rate statute. The landowner's fees are dictated by Section 1. There is, for the, and I think
Who
this...
pays you have this apportionment hearing, which is an hourly basis fee.
Yes, sir.
And that award is against the Expressway Authority?
Yes. It's subsection 2. All apportionment hearings are awarded when you have an apportionment hearing. It's a subsection 2 process. It's a supplemental proceeding after the verdict, after there's been a determination of the value of the entire pie. It's a supplemental proceeding, and so those fees are paid supplementary.
Would both sides get it? Would both parties get it, the landowner and the tenant, if they're arguing over how to divide that $4.7 million?
Yes, in addition to the fee amount.
And so the same would hold true if you had 85% ownership, let's say, and 15% ownership, but the person who has the 15% ownership says, well, wait a minute, that 4.7 figure, that's not right. The landowner had accepted it. It should have been $10 million.
If there is a claim between those two parties as to how to divide the money, that is a supplemental proceeding.
It's not just divide. It's whether that 4.7 was the correct fair market value.
Well, in that case, there hasn't been a determination as to what the entire pie is worth, and you're not arguing over apportionment, you're arguing over the value of the pie, and in that case, the betterment statute is what dictates what the fee is.
But what if the person who has the 85% says, yes, I'll take it? Now, the person who has the 15% says, look, I never would have agreed to 15% of $4.7 million, the property's worth $10 million. What rights does that person have in that situation?
Well, they have let's say their fee interest, they're just a minority fee interest, they obviously have a right to litigate what the value of the pie is. And so what happens, there's a federal district court of opinion that was just decided December 14th. I've learned about it this morning. We're going to file a notice of supplemental authority. What happened in that case is it's an eminent domain case.
If you haven't filed it, you can't argue it here.
All right. Well, then back to your question. What happens is if they're arguing about the apportionment, once the pie's been decided, then that's a supplemental proceeding. If they're not arguing about the apportionment, but they're arguing about the pie, and you have different fee owners that have different ideas about what the pie is worth, then the minority fee owner, in your example, obviously has a right to litigate what the pie is worth. They're part owner of the property, albeit minority. So they have a right to argue about what the value of the pie. They're not arguing about apportionment at that point. They're just arguing about the value of the pie. They clearly have a right to do that.
So does the offer have to be made to each of those owners?
The statute could not be more clear. The statute...
Notice to one is notice to all.
Yes, and the statute says to the fee, it says that the condemning authority must provide a written offer of compensation to the fee owner, and it says as to the value of the property sought to be appropriated. So the statute says two things. You must make an offer of compensation to the fee owner. It's clear that if you have other interests, which you usually do in an eminent domain case, you have a tenant, you have a mortgage holder.
We're talking fee owners at this point. You've got 85%, 15%.
And then it says, as to the value of the property sought to be appropriated. So you make an offer as to the entire pie, the value of the property sought to be appropriated. There's nothing in this statute that says that you make separate offers to separate fee owners. As a practical matter, what condemning authorities do is send the first offer to each fee owner, but they don't go divide it. They send one offer, and it's for the total amount. The fee owners then, amongst themselves, decide whether they want to accept it or reject it. In fact, the statute says that if there is more than one owner of the property, notice to one owner constitutes notice to all the owners of the property, so that you don't sit in a portion. As a practical matter, I would say this: the condemning authorities really can't do that. If you have a linear project that's 10 miles long, which is very common, and you have 200 property owners, those property owners quite often, very rarely is there simply an owner. Almost always there's at least a tax collector, usually a mortgage holder. Quite often there could be a tenant or some other interest, some other fee interest in the property. So for the condemning authority at the beginning of this process to sit and say, okay, we have an appraisal. Now we're going to go apportion this at the beginning of it. And we're going to try and decide what lease interest there may be, and it may or may not be recorded. And we're going to try and decide what mortgage interest there may be when the mortgage amount certainly not of public record. For a condemning authority to, at the onset of that process, to sit and try and apportion all that simply isn't practical. You can't do it. And so in my mind, in my experience, you would grind to a halt trying to build a road, because how do you apportion all this at the early stage? Their argument is, well, you can either ask, which you could, or, and quite often, landowners do not respond pre-suit to anything a condemning authority asks them, or you can file some common law discovery. And in all due respect, if you're a condemning authority and you have to go acquire 10 miles of right-of-way and you have 200 parcels, to sit and try and file common law discovery about each and every parcel because that has some multiple interest in it, you would never get through the process. And the statute just doesn't require that. The first offer statute was adopted in 1999 and then first became effective in 2000. And it's the first time a first offer is required. And it sets out what you have to do. You have to send a offer to the fee owner. And you don't apportion at the beginning of the process. The apportionment is for the end of the process.
But you all put that in there, and that's subject to apportionment, correct, in your offer? Because the Tilden case, I think, is what...
Well, that's one of the very...
That's kind of a concern.
And what happens is, if you do not say, every offer, and in the eminent domain world, every offer is subject to apportionment in reality. The DOT, when they build roads all across the state, they are not going to close on a landowner with an offer if they don't get clear title. And I would submit to the panelists, if what the argument is that suddenly this offer becomes invalid and you cannot use what the statute says you shall use the benefit statute. If that suddenly all becomes invalid because of the word subject to apportionment, what the panel's really saying is, if you demand clear title when you make your offers, then if you demand that clear title, then that invalidates or throws you into paying on an hourly rate. And
what if the condemning authority didn't make a written offer?
Well, if you didn't make a written offer, then the statute just says that your written offer is zero, and so whatever betterment there is, you get an attorney's fee based on the entire award.
So your position would be that it still stays within Section 1 rather than Section 2?
Yes, sir. I think the statute says shall, and shall is very dispositive. It says the fee shall be based on the betterment, except in very minor...
What case do you cite for the proposition that if they fail to do that, that the offer, it's considered an offer of zero, but Section 1 still prevails?
I don't have the cases in front of me, but I'll file... they may be cited in the brief, but I can file a supplemental authority, but that's the case law. So back to what I was saying is, if the position is that suddenly if you demand, the bottom line to this is, if you demand clear title as a condemning authority in order to pay money, and suddenly that invalidates the offer, then in our belief you would have lots and lots of cases where you pay more for right-of-way than what you should pay for it. And let me give you an example. In this case, Door Trust had an 85% interest. Well, Ministry Systems had a 15% interest. That 15% interest was acquired after the offer.
Was it acquired after the offer? Or was it? Yeah, okay.
After the offer, but before...
It was recorded.
It was recorded.
Yes.
It wasn't a record.
It wasn't a record.
Yeah, I think they had it, but it wasn't a record.
Right. When we pulled our title report, we didn't know about it at the offer stage. Right. So if you're saying that, well, a condemning authority can't subject their offer to clear title, then what that means is, in this case, for example, you would have had to pay, let's say you made your offer, I think it's $4.9 million, but whatever that number is. Door Trust says, yeah, fine, we'll take that. Well, under this belief that you don't have to have clear title under this argument, then what happens is you would have had to pay Ministry Systems 15%, which is another $737,000. By the way, you'd have had to pay the tax assessor another $17,000. So the condemning authority would pay $750,000 more for that property because they didn't demand clear title. And by the way, that's if the 15% owner accepted the value of your property. If they didn't accept your value, then it's more. On a linear project, I'll just say this and then answer your question. On a linear project, for the state or condemning authority, that could be an incredible issue. For example, let's say you have your example where you have a 99-year lease, and the ruling is no, you can't say subject of apportionment, you can't demand clear title. Well, in that case, you make your offer, and let's say it's $5 million, and you say, okay, well, the statute says to the fee owner, it has to be for the bundle of sticks. I offer $5 million for the bundle of sticks, but it's not subject to any apportionment. And the owner says, yes, fine, okay, I'll take that, accept it, and it's a contract, and they accept it. Now you have a tenant with a 99-year lease. And what does that tenant do? The tenant says, well, I never accepted any of this. Now you get to pay me $4.9 million. Or let's say there's a mortgage, and the mortgage is most of the value of the property. If the property's worth $5 million, there's a $4.9 million mortgage. Same scenario. You can't say subject to apportionment, and so you, condemning authority, make an offer to the owner for the bundle of sticks. You make your $5 million offer. The mortgage company, it's not subject to apportionment. The mortgage company now comes and says, okay, well, you didn't pay us. They accepted it. We want there's a lien on the property. It's superior to your title interest, and now you need to pay us $4.9 million in order to clear this. What it does is, from a linear project, if the bottom line to this is what they are saying is you cannot demand clear title when you make your offer. And if you do, then you go under subsection 2. And in my mind...
3.5 minutes, just so you know.
In my mind, that eats up the rule, because almost every case has some other interest in it than the fee owner. And if you can't demand clear title, then you are almost always under subsection 2. Thank you.
Good morning. May it please the court, I am Craig Willis of the law firm Fixel, McGuire & Willis, and we represented the fee owners, Door Trust, and Ministry Systems throughout this proceeding. The issue presented in this case is a lot simpler than the Prolex briefs would tend to indicate. There's a couple of quick points I need to clarify.
Yeah, the Prolex brief.
The first point is Mr. Million's point about the tax collector and the mortgage is a red herring issue, because the tax collector and the mortgage are not parties to the litigation.
And really, the Ministry Systems, the 8515, that's not really an issue here. What we're really talking about is the tenants.
Well, the 15% could be an interest if they had a different view than, if Ministry had a different view than Door, right?
As to value.
As to value, well, we're talking about attorney's fees. We're not talking about the litigation over the amount of the fee compensation. And if they were also represented by separate counsel, the facts in this case, the same attorney.
Remember, we've got to write an opinion in this case.
Right.
And that opinion is going to cover scenarios not
like this.
Not just on this case, but on subsequent cases.
Right.
So we can't ignore those issues.
I understand it, and one of the important principles in this case is this statute, benefit statute, is to be strictly construed in the favor of the property owner, because we're talking about the issue of full compensation under the Constitution.
The landowner was fully compensated. What we're talking about is something near and dear to our hearts, and that is attorney's fees.
Well, the courts have said that full compensation includes the concept of reasonable attorney's fees, because if you don't have the ability to hire an attorney and litigate on equal footing with the government.
The legislature passed this statute in an effort to stem what they viewed as a rising tide of excessive fees in eminent domain cases.
That's correct.
All right. So giving some heed to the legislative intent let's discuss it in that context. So
That's correct.
You've got the potential of a 15% or a minority interest that disagrees with valuation. In the second scenario, you have a leasee.
That's correct. But the point that I would like to make is the statute is persuasive, and if it results in situations in which there is not a reasonable attorney fee available to the attorneys, then the statute, the subsection 2 under Sarasota County versus Curry needs to be applied.
Well, Curry was pre-73015, right? I mean, they relied.
Well, Sarasota County versus Curry was a pre-73015, but post 73092 1 and 2.
Right, but this is an offer judgment. This isn't an offer judgment case.
The Sarasota, the second DCA was treating the offer of judgment as the first written offer because it was the first.
Let me ask you this, and here's my concern with the argument you're making. 73.015 sets forth, you're saying their offer is invalid because it says subject to apportionment, correct? For purposes of determining benefits.
That's correct.
All right. So that would seem to give a condemning authority two possibilities. They can either do a subject to apportionment, in which case they don't get the benefit as far as attorney's fees under subsection 1, or they don't do subject to apportionment, in which case, they're throwing out an offer and they may be buying a whole lot less than they intended.
Well, most of these cases are settled pre-suit and do not.
Well, let's take this case, for example. They do a $4.9 million offer, and then afterwards they find out there's a lessee, and by afterwards, I'm saying that they may not know if it's a 50-year lease, 10-year lease, month to month, whatever. So they don't know that, and they don't know if someone else has an interest, like in your case, there's an unrecorded 15%. So are they obligated then to pay Door $4.9 million if they don't put subject to apportionment, and then they may have to pay other people that they don't know about?
The offer in this case was $600,000 over the appraisal of good faith value. Right. And they made it subject to apportionment because they knew there was a tenant on the property. And they intended
like you to specifically answer Judge Evander's question. And it seems to me that's a yes or a no.
If it's an offer that's made exclusively to the owner, then yes.
So they have to pay the owner for the full. If they don't put subject to apportionment, they'd be obligated in this case to pay Door $4.9 million.
What my experience is the condemning authority, if they make an offer like that, then if it's settled pre-suit, then they subject all the interest to the settlement. They require all interest to be resolved.
Can they legally do that? I mean, that seems to be the argument after Tilden in particular.
Well, you can either include everybody in the settlement, or you can exclude them. But you have to make a decision one way or the other.
You give notice to one owner, which you give notice to the fee owner. You only have to give notice to one of them. And you're buying the whole thing.
Notice is different from the attorney fee statute.
No, I understand that.
You only have to provide notice to be able to file your lawsuit.
All right.
So back to Judge Cohen's question on the tenants issue, they in all cases say the property owner settles with the condemning authority and the tenant wants to litigate. Right. That's not an apportionment issue. All of that, if the condemning authority wants to pay an attorney fee based upon that subsection 1 of 73092, they're going to have to make that tenant an offer. That's just the law. If otherwise, they're going to have to pay an attorney fee under subsection 2, a reasonable attorney fee.
Did the tenant in this case, Florida Container, did they make a claim against the money?
They made a separate claim for their trade fixtures, which if they had not settled, the case would have gone to trial and all interest would have been tried together, and then there would have been a post-trial apportionment.
When you all took the money out, the good faith offer.
Yeah, but that does not prejudice them to make a subsequent claim for those monies.
Well, you said the only people that had an interest in the money was Florida Ministries, right? The Door Trust and
Right.
the tax collector.
Right.
You never mentioned Florida
The
Container.
tax collector is not a party. That's an
You said
obligation.
the
that
only people that had an interest in the money, and I assume that's a statutory requirement to get the money out of the court. You said there were only 3 people that possibly had an interest in the money.
Right.
And one of them was not Florida Container.
One of them was Florida Container.
There was the trust, and it was, I mean, that's what I understood.
Yeah,
the
the
trust, Florida Ministries, and the tax collector.
No,
3 people.
the tax collector,
You
the
put
property owner has to pay the tax.
I understand that.
The tax collector is.
Did you file
filed
a pleading saying that the only parties having an interest in this deposit money and withdrawing it was the tax collector, ministry, and door? That was the question that Judge Jacobus asked.
4.3 million.
I mean, did you all file that plea?
4.7 at that point in time.
Right.
So they paid
I believe that is correct. That's what Mr. McGuire did file in this case, but in fact, the tenant, the Florida Container, had an interest in that money.
So is it irrelevant that your client represented to the court that the tenant had no interest in that money?
I think that was probably a mistake, but I don't think it prejudiced. I don't think it was to the Florida Container's prejudice, because they had a right to claim those funds, even if they were paid out to.
I don't think under the lease they.
The facts in this case, they didn't. They were on a month-to-month lease, right?
Yes, and then they had a trade fixtures
And
claim.
you had, yeah, but that's separate. That's a different deal, isn't it?
Well, no, the trade fixtures is a part of a fee ownership, the fee ownership, total interest in the property, and if it had gone to trial and litigated all the way through, there would have to be an apportionment of the trade fixtures. It is.
had some clause in it that kind of said what happened on condemnation too, I think, did it not?
It did, and that clause said.
A lease?
The lease.
See, that's another misleading issue that
You disagree with that lease?
The lease was expired with a prior tenant.
Okay.
There was no lease. There was no lease with the current tenant. That's another red herring issue in this case, Your Honor.
It was a month-to-month.
It was a month-to-month, but under Pensacola scrap, even a month-to-month tenant is an owner of real property for purposes of Florida law and had a claim in this. The Expressway Authority didn't know whether they were on a month-to-month or a 99-year lease.
Right.
All they knew is there was a tenant on there, and they wanted that tenant included in that offer for an uncertain amount. Right. And the amount of the offer was $600,000 over their initial appraisal. So they clearly intended a bunch of money to potentially be available to this tenant without identifying how much of that money was to be.
Or they were trying to make a good faith offer to settle the case.
Well, or an offer that, was for a lot over. But see, the problem is the benefit statute either means what it says or it doesn't. And if you can determine the benefit, fine. And you award an attorney fee pursuant to that.
Why can your client determine the benefit? Because you got an offer from them. You represented to the court that the tenant had no interest in that money, had no right to that money. So why can't you figure it out?
Why can't you figure it out? Because the tenant did have an interest.
Well, but why did you said it's a mistake, and I agree it wouldn't prejudice Florida Container, but y'all represented to the court that Florida Container had no interest in that money.
That's not true.
Well, you filed a pleading and said the only parties that have an interest in this deposit money are the tax collector, ministry, and door.
That's not correct, Your Honor.
Are you saying that y'all didn't file a pleading that said that?
That's what, Your Honor?
Y'all didn't file a pleading that said that?
I understand that Mr. McGuire made a pleading in his motion to withdraw the funds that indicated that, but I'm telling the court if that's what he did, and I seem to recall that that's what he did, that's an error. And it
Well,
was,
let me ask you, you put somebody else
and the Expressway Authority knew the tenant had an interest, and they litigated with the tenant for that interest. And the court system, all that offer intended to cover the tenant's interest.
Let me ask you this, Mr. Willis, help me out here. When you take the money out on the quick take money, I guess, the good faith deposit, if you put other people has an interest? In other words, if you put like Florida Container had an interest, would they give all the money to you, or would they hold money back, or what happens when you do that? In other words,
Well, often-
are you able to take the money out? Because it seems to me that doesn't make sense. The reason you have to say that is to protect all the people that might have an interest. In
Typically-
this particular case, the two people, the two fee owners, the 85 and the 15, were represented by the same lawyers, so it wasn't a problem. But
Typically, what I do is I reach an agreement with the tenant's
you're
attorney
gonna give
that I hold some of it back or to cover their interest. If they have a 99-year lease, they're going to be asking for a whole lot more than if they're on a month-to-month. These are issues.
My question specifically is, if you had put Florida Container in that, I forget who filed it, but if he put that in there, would you have gotten all the money, the $4.7 million out, or would they? You'd have to say no, you don't, or everyone.
There would have been a settlement.
Everyone would have to have agreed, right?
There would have to have been an agreement.
Yeah,
Your Honor,
okay,
yes.
I get you. All right.
So Florida Container, if you had put Florida Container down in that pleading, and unless you had an agreement with them, you wouldn't be able to withdraw all that money, would you? Without a court order.
Without a court order or making some preliminary apportionment. That's correct.
Okay.
Was there ever any pleading filed subsequent to Mr. McGuire's filing of that one pleading indicating in any way that that was a mistake?
Well, I know that Florida Container was noticed with that pleading. They did not make a claim for that money. They subsequently litigated with the
Is that a yes or a no?
a subsequent pleading.
Is there any pleading that suggested that that was a mistake?
I'm not aware of one, Your Honor. I am aware that they were noticed with the pleading, that they were noticed with the hearing. They made a subsequent claim for trade fixtures. They litigated with the Expressway Authority, and they were able to reach a mediated settlement agreement in the spring of 2007 for their trade fixtures and any other moving expenses that they might have.
Let me go back to the topic I had asked about earlier. How is the Expressway Authority supposed to comply with 73015?
They did comply with 73015 in this case.
By saying subject to apportionment.
But
by doing that, so does that mean in any case in which there's multiple parties that as a practical matter the benefits section of the attorney's fee provision is no purpose?
I don't agree with that because how the tenant's interest was involved 9 months later after the offer was made is the Expressway Authority had a trade fixtures appraisal, and Florida Container had a trade fixtures appraisal. They swapped appraisal reports and settled the matter. The Expressway Authority could have easily determined what the nature of the leasehold estate was, and had somebody.
How would they easily do that?
Yeah, how would they easily do that?
How would they easily do that?
This is
Well, first of all,
pre-suit.
It's pre-suit. You go in, you ask for the lease from both the tenant and the property owner. Both of them.
And they both ignore you.
They both ignore you. Then you file a pure bill of discovery.
So on a stretch of 20 miles where you have hundreds of parcels, you've got to engage in pre-suit discovery, common law discovery, to be able to make offers.
I would guess that it would be very seldom that you would have to do that, Your Honor. These projects, you have to remember.
The theory that you're espousing, theoretically, that could
Theoretically, that could happen. These projects go on for years in the planning stage, 2 or 3 years. They hire engineers, they hire appraisers.
How is that scenario consistent with the legislative scheme to resolve these cases and to cut down on the attorney's fees?
I'm not saying that the benefit-based statute provides a smooth and easy process for all of this. What I do say is if the condemning authority of the government is going to limit attorney's fees, which Judge Sharp has already talked about many years ago as potentially suspect, If the
But there was
government
no
wants...
constitutional claim made in this case.
Yes, there was a constitutional claim made.
Yeah.
We have
Let's
preserved
assume
that.
All right, let's assume that there's $1 million offer and the $1 million verdict.
No benefit.
No benefit.
Right. And so how are you going to, what is the court going to do? Well, the court has subsection 2 to apply in determining what a reasonable attorney fee is. That's not a big deal. I don't understand why the government thinks it's such a big problem to award a reasonable attorney fee. That's what the courts have been doing from the beginning of time. In those rare cases where you have to litigate either extensively or you have to litigate without the benefit
So
of
doesn't that
subsection 1.
effectively trash subsection 1?
No, it does not. Subsection 1 has a wide ambit of application, but there's going to be some times, there's going to be gaps where subsection 1 is not appropriate, and this is one of those times.
So it seems like the gap where it'd be inappropriate would be every time there was more than one interest.
The condemning authority has the ability to determine what the respective interest of the tenant and the property
Only by
owner...
initiating new litigation, because otherwise they can be ignored. They don't have any right to compel.
They have a
Look at
right...
this case. They don't even know about Ministry's 15% interest, and they don't have a right to the lease unless they initiate new discovery. I mean, a new lawsuit.
Well, as to Ministry Systems, it was a set percentage of owners.
But I mean, it wasn't of record.
It wasn't of record.
So they
It's
had no
not an
knowledge.
issue. The tenant is
It could
always
be. It
going to be a
wasn't an issue in
potential
this
interest.
case, but it could have
But
been.
it could be.
Yeah, and the tenant is more likely to be the problem in these kinds of cases.
Right.
And when the condemning authority, they knew there was a tenant there, they served the tenant.
They were
could
a
have-
party, right.
They could have easily sent in a trade fixtures appraiser to go into the property, appraise the trade fixtures, and obtain the lease. A lot of times these leases are of record. If they're not of record, they could ask for it if they were refused. And it's one of either the tenant or the property owner is always going to have an incentive to disclose that lease. The tenant, if he's got a 99-year lease, wants the government to know he's got the vast bundle of sticks. And in those rare cases where he cannot, he refuses, they have a discovery indictment.
Would you agree that the offer of judgment body of case law is dysfunctional at best?
Yes.
Yeah.
And what your argument is effectively is to graft that dysfunctional body of case law into an eminent domain scenario.
No, Your Honor, I'm not asking that at all. All I'm asking is that the benefit be discernible and the benefit be specific. And I would like, I see that I have only a few seconds left.
Actually, you're over.
I would like to remind the court that we do have an unresolved constitutional claim that the trial court did not have the opportunity to address. It would need to be remanded if this court rules against us. I believe that the trial court's finding of an attorney fee that's vastly in excess of the benefit-based statutes that the government's urging is an implicit determination that there is a constitutional as applied problem in this case.
So if we were to go to the benefits, there still may be a constitutional argument you should get more than that. Correct?
Yes.
Mr. Willis, let me ask you what, don't you think the owners or the people that have the interest in the property, the lessee, the fee owners, are in a better position to figure out how much each is worth than the condemning authority, at least on the get-go?
Well, certainly that's true, but that would require some type of legislative amendment like the business damage statute where they require the business owner to make an offer initially. They address that particular issue.
Thank you very much.
Thank you.
How much time do I have, Governor?
I'm going to add some time because we let your opponent go over. I'll give you
5 minutes.
I'll give you 4.5 minutes.
Thank you. I want to really focus on two issues. The first is, I think, a big picture issue in this case, and that is, what is the policy that's being argued here? This is not an academic issue for anyone that represents governmental entities or governmental entities trying to build linear projects. What they are saying is that those entities have two options when they make their first offers. Option 1 is you don't make it subject to apportionment. You just avoid this issue. You don't make it subject to apportionment. When the statute says you make a written offer to the landowner for the entire bundle of sticks, you just do that. I would submit to this court that this is not an academic issue, that if you go and do that as a condemning authority and you make on a linear project with a $200 million right-of-way budget, you make those offers to the fee owners, and you do not clear the interest of the mortgage holders, and you do not clear the interest of the tenants, you are going to pay many times your right-of-way budget for that land. In this day and age, mortgage holders alone will have as much interest as property owners because lots of properties are underwater. It's not an academic issue. If you choose to say as a condemning authority, well, we just want to make sure we're under subsection 1, and by golly, we're not going to make it subject to apportionment, you are not extinguishing many interest. And on a linear project, your right-of-way budget will be incredibly different than your appraisals. No condemning authority is going to make that decision. They're not. They're not going to say, well, okay, we're the steward of taxpayer monies, but we're just going to make offers to fee owners, and we're disregarding whether they give us clear title, and we'll just have to let the chips fall where they might, and we'll just have to go deal with the tenants, and we'll have to go deal with the mortgage holders. No condemning authority is going to do that. So then what's going to happen? You are going to have cases where every landowner is going to stand up and say, hey, it didn't say apportionment, subject to apportionment. It didn't say who got what, and so we don't fall under subsection 1. Subsection 1 will become essentially meaningless because almost every case has an interest.
All right, my question before, where you had $1 million offer, $1 million judgment, no fees.
If you have $1 million offer and $1 million judgment,
After trial.
At the trial level, that may just be the burden of the statute. I mean, you can have cases where you make lots and lots of money as an attorney because you really beat the first offer. And the quid pro quo to that is, well, there are cases where you don't make much money. And what you're asking is about the case where you make none. Well, first of all, if there's no betterment, there may be no fee. Now, does the trial court then have the discretion to evaluate whether the fee is unconstitutional as applied? I think they may have. I think that would be an appellate issue.
Well, how about here? The hours that the condemning authority's attorneys spent on that case were no less than the amount that that the fee owner.
Well, that's what I want to address. That was the last thing I wanted to address because it hasn't been argued to the panel, and that is whether this is unconstitutional as applied. And I would have several comments for the panel's consideration. The first, and I think
the trial judge didn't get that.
That's right. The first and most paramount issue is it was presented to the trial court. The trial court heard argument about all of this. He heard testimony about all this. It was a 3-day fee hearing. There was a proposed order submitted to the trial court that had all of that language about unconstitutional as applied, and he didn't enter any of it.
Right, and that's appropriate for him not to do it because you don't address the constitutional issue normally if you can address it without addressing, if you can make your decision based on the statute. So the fact that the trial judge didn't do it in this case doesn't mean he rejected it. Just means it was unnecessary for him to address it.
Well,
in his mind.
Or he could have done an order, which many trial judges will do, that says, I find the offer invalid and I also find the fee based on the betterment unconstitutional as applied. I'm just saying that whether he on remand would consider that, I don't know, but he certainly heard all this and didn't. The second.
Well, let me ask you: are you taking the position that the trial judge rejected the constitutional argument? Are you taking the position, or are you willing to concede that he did not address it?
No, I think he rejected it. I think he heard days of that. It was argued, as you can tell from this, that people are passionate about this. I think he heard strenuous argument about this.
So all the case law that says if you can address something without addressing the constitutional issue, you should do so. We're supposed to reject all of that?
Well, I'm not suggesting that.
Well, I mean, to me, the trial judge did exactly right by not addressing the constitutional issue if there was no need to.
The second thing I would say about the unconstitutional issue is What they are saying is the betterment statute was $227,000, that's the fee under the betterment statute. The betterment was $830,000. What they are saying is that somehow $250,000 is unconstitutional as applied. And I'd submit to the court, there is no case that says anything like that. The cases that say that it's unconstitutional as applied, most of them say it might be. They don't even rule that it's unconstitutional as applied to the betterment statute. They just say there could be examples of that. And those cases are fees of $2,000, $3,000, maybe a fee of $0. That is a far cry from $250,000 to say that $250,000 is unconstitutional as applied. There's no case that gets anywhere close to that. Now,
All right, your time's about up. If you want to wrap it up real quick, I'll let you do that.
well, the only other thing I would say is that they pointed out that the Expressway Authority expended considerable hours, and I would submit to the panel that those arguments go back and forth. They had double the number of experts. They spent 900 hours in trial prep, which is 22 weeks. They spent 1,350 hours on an economist, which is $500,000. So those arguments about who spent what time go both ways. And in my mind, I respectfully understand what you're saying. In my mind, the trial court certainly heard all of that and entered the ruling he did.
All right, thank you. Thank you both. It's an interesting case.
Well argued by both sides.